Hello, everyone. My name is Debbie Longo, and I'm the Transaction and Compliance Coach for the PC program here at Keller Williams Realty Success. Today, we will be discussing exclusive buyer agency agreement with consent to designated agency and consent to dual agency. So this is a form that when you work with a buyer, you need to have this signed. This is your contract with the buyer. It protects you, it protects them, it protects the brokerage. My deep down heartfelt recommendation is to never work with a client without a contract. And you need this form signed in order to get paid. So as usual, we'll go over the terms of the form and the information, and then we'll learn how to properly complete the form. As always, I'm available for one-to-one sessions if you need further assistance. This is a form that's found in your binder. So if you can turn to the transaction section, I would prefer that you use the forms in your binder so you have a template for reference. So again, this is the exclusive buyer agency agreement. This means that your buyer or buyers work with you and you alone. They're actually working, this contract is with the brokerage, with you being the representative of the brokerage. So this exclusive buyer agency agreement is made between the buyer and Keller Williams Realty Success as the broker. In consideration of the mutual promises set forth below, buyer and broker agree as follows. 1, exclusive buyer agency. Buyer grants to broker the exclusive right to locate or procure real property acceptable for purchase or lease by the buyer. Buyer further agrees to refer all potentially acceptable real property to the broker during the term of this agreement and agrees to notify all other real estate agents who communicate with buyer of broker's exclusive agency relationship with the buyer. The final decision whether or not a property is acceptable for purchase shall be solely within the discretion of the buyer. So this first section is important when you have buyers going to open houses or trying to schedule showings through websites. They log on to the many websites that are out there, and they just click and they connect with a buyer's agent or somebody, the listing agent, somebody representing something, somebody paying for something. This is a contract that says that they can't do that. This is a contract that says that you represent them exclusively. So any other agent that contacts them is in violation. Something you can consider. Something to explain to the buyers when you meet with them. So 2, term of agency. So the term of this agreement shall be from, and in this section, I usually put in 6 months to a year, especially in these times. A lot of people only want to do it for a couple months, 180 days, whatever it is. It's a term that you agree with your buyers on. Unless extended verbally or in writing or terminated by completion of the purpose or by agreement. So number 3, broker's service and duties. Broker agrees to use reasonable efforts to locate real property acceptable to buyer and to assist buyer to negotiate terms and conditions of a contract acceptable to buyer for the acquisition of the real property, the contract. The contract may consist of an accepted offer, purchase and sale agreement, option, deed, exchange agreement, lease or similar instrument. Broker agrees to assist in locating properties, arrange showings, analyze financing alternatives, give advice, concerning real estate practices and procedures, assist in negotiations, arrange inspections requested by buyer, and coordinate activities throughout the process. Buyer agrees that such services do not constitute a guarantee or warranty concerning any real property. Buyer agrees that the broker has not retained an attorney, has not been retained as an attorney, an inspector, a home inspector, pest termite inspector, septic inspector, surveyor, or to determine the condition of the real property, and has not been retained to act as a mortgage broker. Buyer agrees that the broker shall have no duty to disclose any matter or condition outside the boundaries of the real property being considered for purchase, including, but not limited to, present conditions and anticipated changes in the neighborhood where the property is located. Broker recommends that an attorney or other professionals be hired for such services as buyer deems appropriate, and that the buyer personally investigate particular matters which may be of importance, including, but not limited to, neighborhood composition, the level of crime, and the presence of sex offenders. Broker agrees to preserve confidential information of buyer, making disclosure of confidential information solely to the extent necessary to establish buyer's financial qualifications. Buyer is advised that sellers or sellers representatives are not required to treat the existence, terms, or conditions of an offer as confidential unless a confidentiality agreement has been made with the seller before submission of an offer. Buyer understands that broker represents other buyers and agrees that it will not constitute a breach of duty for the buyer's agent to introduce another prospective buyer to a property in which a buyer may be interested in, or to assist another buyer with a purchase. Broker shall maintain confidentiality of material information for each buyer. Should either party file a claim for violation of general laws, Chapter 93A, the prevailing party, including any agent of the broker, shall be entitled to recover reasonable attorney's fees, but no fees and costs shall be recovered in the event that a tender of settlement was made in advance of suit but rejected, and the court or arbitrator determines that the rejected tender was reasonable in relationship to the injury actually suffered. So buyer's duties. This is important because a lot of times the buyers don't think that they have an obligation, or they don't understand their part of it. So this is something that you need to discuss with them and make sure that they understand what their duties are. So the buyer agrees to work exclusively with the broker, during the term of this agreement. Buyer agrees to conduct all negotiations with the knowledge and assistance of broker. Buyer agrees to cooperate with broker by providing relevant personal and financial information and to cooperate in scheduling and attending showings. Buyer agrees to advise broker of any interest in purchase or lease of real property about which buyer was previously advised by any other person. Buyer shall provide any lender's letter of pre-approval or pre-qualification to broker within 7 days of receipt. Buyer agrees not to attend open houses without advance notice and approval of broker, and agrees to advise each listing broker at each open house of buyer's agency relationship with the broker. Buyer represents that buyer is not subject to any earlier agency agreement with any other broker or any protection period. Buyer understands that this agreement does not relieve buyer of the duty to exercise due diligence for buyer's own protection, including the duty to investigate any information of importance to the buyer. Buyer further understands and agrees that the broker may show other prospective buyers properties in which buyer may be interested. So when you send your buyers out to open houses, or they want to go take a Sunday and look at 10 open houses, do you need to accompany them? No. Do they need to let people know that they are working with you? Yes. So when they sign in, they can put down their name, but your information. That way, it also prevents the other agent from contacting your client directly, and they need to communicate through you. So broker's compensation. Buyer agrees to pay the broker. So I'm not one that uses a retainer. Some people do. I don't know of anyone that actually does, but this is something that, as I said, some teams do, some agencies do, some brokers do. Just put down a retainer amount that they're to solidify the contract. What I do is I base things on the success fee. So once the property closes, the brokerage is compensated. So B, success fee. The parties agree that the compensation equal to, normally deals are between 2-3% on the buyer side. There is no confirmed number that you need to use, but it's a number that you want to be specific about before you enter into this contract with the buyers. So the parties agree that compensation equal to insert percentage of the purchase price or another amount shall be due the broker upon successful completion of this agreement, or in the event that within however many days following the term of this agreement, buyer or any person acting for or with a buyer purchases, leases, or otherwise acquires an interest in the real property after becoming aware of the availability of the real property or receiving information about real property during said term. So this is extremely important, because you don't want somebody going and looking at a property that you are working to find them, and then having them decide to cancel the contract and then put an offer in directly with the seller or another agent. So what this says is that you have a contract that is a certain number of days. I usually put in this box within 60 days. So within 60 days of the end of the contract, whether it is by the contract running out or the buyer dismissing the contract somehow, that any property that you have introduced them to, within 60 days of that deadline, if they purchase it, you're entitled to procuring cause, which means that the brokerage is entitled to a fee, the fee stated on this contract. So the parties agree that the broker shall first seek compensation, if any, offered by the listing agent or otherwise from the transaction, the listing broker or seller. If obtained, such amount shall be credited to the amount of the success fee. If such fee cannot be obtained in whole or in part from the transaction, buyer agrees to pay broker the success fee due at the time of closing. So if something is not offered to you or to the brokerage in a transaction for sale by owner, just isn't, this amount isn't equal to what is offered by the seller or on the listing. Whatever the amount is that you put here, the buyers are agreeing to. So if the listing only applies to 2% and you put 3% or 2.5%, the buyers are responsible for the difference. Having this contract helps you to collect that money for the brokerage. C, all fee disputes, claims, or controversies arising out of or related to this agreement shall, upon demand of either party, be submitted for binding arbitration to the local association or board of realtors. Or in the event the association board declines to hear the matter, to the American Arbitration Association. Or upon mutual agreement to another dispute resolution service. The Realtor arbitration proceedings shall be conducted by a panel of 3 arbitrators according to then current rules of the Association of Board of Realtors. Or if before AAA, by a single arbitrator according to the consumer arbitration rules, or if not applicable, the commercial arbitration rules by AAA. And all proceedings will be conducted at a location in Massachusetts chosen by the arbitrator. Reasonable attorney's fees and costs shall be awarded to the generally prevailing party in the arbitration. So consent to designated agency. Now, this is something that we went over on the mandatory disclosure. This gave information about how people can be represented. So this one is giving consent to designated agency, which is what our office is. A designated agent is a real estate licensee who has been appointed by a broker or salesperson to represent a buyer as a designated buyer's agent, or to represent a seller as a designated seller's agent. When a buyer or seller consents to designated agency, only that designated agent represents the buyer or seller. Any other agents affiliated with broker may represent another party to the transaction, and by consenting to designated agency, the buyer or seller permits those agents to represent another party. Individuals who are designated agents owe fiduciary duties to their respective clients. You are further advised that A, the designated buyer's agent will represent the buyer and will owe the buyer the duties of loyalty, full disclosure, confidentiality, to account for funds, reasonable care and obedience to lawful instructions. B, all other licensees affiliated with the appointing broker will not represent the buyer, nor will they owe other duties specified in paragraph A to the buyer, and may potentially represent the seller. And C, if designated agents affiliated with the same broker represent the seller and buyer in a transaction, the appointing broker shall be a dual agent and neutral as to any conflicting interests of the seller and buyer, but will continue to owe the seller and buyer the duties of confidentiality of material information and to account for funds. By signing this agreement, the buyer consents to designated agency. If designated agency occurs in a transaction, a notice of designated agency will be given. The designated agent or agents for the buyer are, so my name goes on here, or the name of the agent that's representing them. In the event the designated agent appointed to represent buyer ceases to be associated with the broker, buyer hereby consents to appointment by broker of one or more agents associated with the broker to represent the buyer. Written notice of that appointment shall be given by the broker to buyer in a timely manner. 7, consent to dual agency. The buyer understands that the designated buyer's agent with whom buyer is working also represents the sellers, and that if the buyer is introduced to a property listed by that agent on behalf of a seller, a dual agency will be created. The designated buyer's agent may act as a dual agent who represents both prospective buyer and seller with their informed written consent. A dual agent is authorized to assist the buyer and seller in a transaction, but shall be neutral with regard to any conflicting interest of the buyer and seller. Consequently, a dual agent will not have the ability to satisfy fully the duties of loyalty, full disclosure, reasonable care, and obedience to lawful instructions, but shall still owe the duty of confidentiality of material information and the duty to account for funds. Buyer understands that material information received from either client is confidential and may not be disclosed by a dual agent, except for 1, if disclosure is expressly authorized. 2, if such disclosure is required by law. 3, if such disclosure is intended to prevent illegal conduct. Or 4, if such disclosure is necessary to prosecute a claim against a person represented or to defend a claim against the broker or salesperson. This duty of confidentiality shall continue after termination of the brokerage relationship. When the agent with whom the buyer is working is a dual agent, that broker with whom the agent is affiliated is also a dual agent and shall remain neutral as to any conflicting interests of the buyer and seller. By signing this agreement, buyer consents to have designated buyer's agents act as dual agent. Except as expressly provided, this dual agency shall not extend to other licensees affiliated with the broker. If dual agency occurs in a transaction, a notice of dual agency will be given. As I said, that's something that we went over on the mandatory disclosure, but this gives a little bit more information. So number 8, disclosure of identity of other brokers, other potential buyers. Broker is authorized to disclose buyer's identity. Broker is authorized to cooperate with and pay compensation to other brokers in connection with the performance of broker services. Buyer understands that broker may represent other buyers interested in purchasing the same or a similar property. Buyer consents to such representation. It's important that they understand these things, that it's gone over word for word, it's understood, it's acknowledged, it protects everyone. Again, you want to have educated consumers. Entire agreement governing law. This agreement is the entire agreement between the parties. It is binding upon the parties' heirs, successors, and personal representatives. Assignment shall not limit the rights of broker. This agreement shall be governed by the laws of the Commonwealth of Massachusetts. Unless otherwise stated, this agreement may not be modified except in writing by writing signed by both parties. So there's a space on here that you can have other provisions. If there's something specific, if they're going to buy their mother's house, if there's a specific property that they want excluded, if there's a specific term that they want in here, you can put that in other provisions. It just has to be agreed upon by the agent, the brokerage, and the buyers. So this document creates binding legal obligations for legal advice, consultant, attorney. So again, not much to fill out on this form. As I said, the name of the buyer, the name of the brokerage, the term of the agreement, the fee, how many days after the expiration of the contract do you still have the ability to collect a fee, the name of the agent that is representing the buyer, any additional information that you want to put in the contract. They need to date it. The buyers will sign it. And you will sign it as well. Where it says broker or authorized representative, you are that authorized representative. So if you have any questions on this, we can discuss. As I said, I'm available for one-to-one discussions, one-to-one meetings to go over this further. If you have any questions, let me know. Thanks.